Good morning. I'm Judge Ryan Sullivan. I'll be conducting the hearings today. And before we begin, Mr. Lucia, are there any cases you'd like me to hear early on today?
Good morning, Your Honor. None from the state side.
Ms. Lopez, are there any cases you'd like me to hear early on this morning?
No, Your Honor. Everything's normal here.
All right. So we will start with the first appearance from Michael Mayorga.
Yeah.
Good morning, Your Honor.
Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Thank you, Your Honor. The state's asking that the court set Mr. Mayorga's bail at $2,500 with conditions to include no alcohol, drugs, or paraphernalia subject to testing and random supervision. The state's concerns here lie more on the fact that Mr. Mayorga's prior criminal history and ties to the area as they relate as opposed to community safety. He's a 12 on the risk assessment. It noted that he lives in California. He had an active warrant at the time of his arrest in this case for a case out of Sparks Municipal Court for failing to appear. His criminal history goes back to 2005, and more recent entries include misdemeanor convictions for trespassing, disorderly conduct, 2021 case for contempt, a 2020 case for contempt, convictions for domestic battery, more probation violations all the way back to 2014, felony charges for battery by a prisoner, more felony convictions for possession of stolen property, convictions for theft, assault with a deadly weapon in California, fugitive from justice in 2007. So given the ties to the area, as well as that extensive criminal record, the state has concerns about the defendant's flight risk and risk of ongoing criminal conduct.
For the defense.
Your Honor, Mr. Mayorga does live in California, but it's not like he lives in San Diego. He's in Truckee, so he is part of this community. If the court puts him on any kind of supervision, he's close enough that he would be willing and able to comply with those terms. Mr. Mayorga indicates that he would be willing to submit to drug testing if the court released him with drug testing. He can check in with pretrial services or with the Reno Justice Court upon release. He does have two holds right now out of the Sparks Municipal Court. One of them is for $1,000 bondable. The other one is for $890 bondable. So the bulk of any income that he may have is going to be going towards resolving those two matters. I don't think he's going to be seen on that today. He should be seen on it sometime this week. He has been employed at a concrete company for over 6 months. He's been at his address for over a year. He does receive benefits. He has Medi-Cal and he receives food assistance. So he does know how to, communicate with government agencies and how to comply with requirements to get those applications done. So with all that being said, Your Honor, Mr. Mayorga indicates that he would be willing and able to comply with any conditions that the court felt were appropriate to reduce the risk that he would fail to appear and to keep the community safe. These are non-violent offenses. It looks like he is just being charged with possession. So we would ask that the court consider releasing him on his own recognizance with supervision.
The problem is failure to appear. Not only does he have 2 open matters with Sparks Municipal Court, but he has a history in addition to that of not complying with and showing up for court orders. In addition, he scores a 12, which is very high. Therefore, I believe that I must set some monetary bail. I'll set it at $1,000. That's bondable or 10% cash, which takes into consideration that these are nonviolent allegations. And if he posts that and his holds get cleared through other courts, he'll be subjected to Reno Justice Court monitoring. Thank you.
All right, Mayorga, you can have
Next, we have first appearance for Brianna Vicente.
Good
Morning. Probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Your Honor, Ms. Vicente has no prior criminal history whatsoever. She scores as a 3, which is low on the risk assessment. So in light of those facts, the state would be recommending an own recognizance release on the sole condition that she comply with CPS if they're involved in the case at all.
I intend to do that. Anything you'd like to add, Ms. Lopez?
No, Your Honor.
All right. So, Ms. Vicente, I'm going to release you, but your case here is not over with, okay? This is a criminal matter, and that's separate from the case you have with social services. So you need to show up for your next criminal court date. I'm going to set that right now. It's August 13th at 9 a.m. Make sure you're here. And the condition that I'm going to give you is you have to comply with human services. So whatever they ask you to do for your family court case, whether that's classes or testing or supervision, you have to do that. All right. So make sure you comply with human services and show up at your next court date. Thank you.
We're gonna give you some paperwork and you better just, but it's gonna take a few hours. You should be there.
The next matter we have is first appearance for Lawrence Brown.
You don't have to.
This way, ma'am.
Your Honor, Mr. Brown is not present. He waived his appearance, but we are prepared to move forward in his absence.
All right, thank you. Probable cause is found. The public defender is appointed. Let's start the bail hearing with the state.
Your Honor, the state would ask that the court set Mr. Brown's bail at $40,000 with no 10% cash option, given the nature of the allegations. As the court notes from the probable cause sheet, these are allegations involving a physical confrontation, allegations of robbery. More concerning to the state is the introduction of a firearm, which is alleged. Mr. Brown directed a female to produce the weapon and ultimately kept imploring her to shoot the listed victim, in this case, Mr. Montre Davis. With respect to conditions, the state would ask that the defendant have no contact with Mr. Davis. The listed victim in this case have no contact with the co-defendant, Ms. Angelia Collins, that he possessed no weapons and be subject to supervision. He comes to us as a 9, which is higher on the risk assessment. He notably declined to give a reference to pretrial services and has a conviction that's concerning in terms of the instances of prior violent crimes. In 2026, the defendant actually was convicted of carrying a concealed weapon on a case that began with allegations of assault with a deadly weapon, where he was alleged to have pulled a firearm on a group and threatened them with a gun following an argument. He was actually just sentenced to diversion on that case in April of 2026, so 3 months ago. In addition to that recent conviction, he's got a 2022 domestic battery arrest. Looks like he was convicted on some sort of a charge. I can't see from his criminal history what that was out of the Sparks Municipal Court. He's got a violation of a protection order conviction in Oakland in 2016. He's got a felony arrest for possession of a controlled substance while in prison in San Francisco. That case was ultimately deferred on agreement that he revoke himself from his parole. It looks like there's another entry for battery with substantial bodily harm and carrying a concealed weapon out of Oakland. He's got a misdemeanor conviction in 2015 for carrying a concealed weapon, as well as battery in Hayward, California. He had a misdemeanor conviction for vandalism and a felony arrest for assault with a deadly weapon in 2014. So given that history with weapons offenses, given the allegations in this case, given the fact that he's been on probation for 3 months, the state has extreme concerns about the threat he poses to the community and his risk of ongoing criminal conduct.
Thank you. For the defense.
Your Honor, he does score a 9 on the risk assessment initially. However, we were able to reach out to a reference of his father, Lawrence. He's been working at a company called Covenant Cleanup. That job has been a couple of weeks / months. It's not that long, but he is gainfully employed. He does have an address. It is at a motel, so it's stable, but it's not like he has a lease. All of that to say, Your Honor, that he is in a precarious position. He is in a position where if he doesn't get out of custody, those things that he is barely just now starting on the path to stability are going probably to evaporate. He does have a hold out of the Second Judicial District Court, and I do understand that. We are asking that the court consider setting his bail at $2,000 bondable. I understand that for this type of offense, it's not likely that he will get that 10% cash. But we're concerned, Your Honor, that he is not, all of the stability that he is working towards is going to go out from under him if he's not able to get out. And really, it's going to be that's going to help him come back to court and help the community, help protect the community, because people that are stable are less desperate. So we are asking that the court consider setting a bail within monetary reach, understanding that he does have a holdout of the Second Judicial District Court. And even if this court does set a bail that he can afford, he's unlikely to be released soon.
So this allegation is very serious. The victim positively identified him as the one who punched him in the head repeatedly, took his dog and tried to escape with his dog, and then instructed the co-defendant who had a gun to shoot him, the victim, multiple times as they were trying to flee, in which a parked car was also hit. So this is very risky behavior to the community. He was just sentenced. In addition to that, he has a record. I think that absolutely there's a risk and monetary bail is appropriate. I will set it at $40,000 bondable. No contact with Montre Davis or Angelia Collins. No weapons and supervision by pretrial services if he posts and the hold's lifted. Next, we have a first appearance for Christopher Caspary Bugley.
Good morning, Your Honor.
Good morning. Probable cause is found. Public defenders appointed. Let's start the bail hearing with the state.
Thank you, Your Honor. The state's asking that the court set Mr. Caspary Bugley's bail at $15,000 with conditions of no alcohol, drugs, or paraphernalia, random testing, and supervision. The allegations here are DUI, but concerning to the state is the defendant's ties to our area as well as his prior criminal record. He's an 11 on the risk assessment, notably only in Northern Nevada for 2 months. He declined to give a reference and was assessed as a high risk, high needs on the DUI RANT device. With respect to his prior criminal history that's borne out by virtue of the numerous instances of prior DUIs that he's incurred, he's got a 2023 conviction for DUI out of California, 2021 contempt case out of Douglas, a 2018 felony conviction for assault with a deadly weapon that carried with it a probation violation. That same year, he was also convicted of interstate drugs as well as a misdemeanor DUI. There's another case in 2016 that was dismissed because the victim declined to testify out of California. Another felony conviction in 2015, it looks like, for assault with a deadly weapon that was put down from battery with substantial bodily harm in California. And yet another misdemeanor DUI conviction in 2010. So from 2010, this represents the fourth instance for which Mr. Caspary Bugley has been before a court on allegations of driving under the influence. And that history is punctuated by instances of more escalated victimization, which underscores the state's concerns that he presents as a threat to the community, and thus some form of monetary bail is necessary to hopefully assuage those concerns.
For the defense.
Your Honor, we are asking that this court consider releasing Mr. Caspary Bugley on his own recognizance with the following conditions. We would ask that the court begin the PSS process. We would ask that Mr. Caspary Bugley be ordered to 3 self-help meetings per week while he begins the process of getting into treatment. We were able to reach out to his father. His father's name is Neil. His father confirmed that Mr. Caspary Bugley lives with him in Gardnerville, confirmed his job, confirmed his, not just his address, but also his phone number, and said that, you know, he's a stable guy. I understand that he has several DUI arrests, and the rant indicates that, you know, there may be some risk. However, those are risks that can be mitigated with conditions. We also would ask the court, if the court feels comfortable in imposing an alcohol monitoring with OSM or even with an ankle monitor and a no driving clause. Mr. Caspary Bugley does have a history. We recognize that, but there are conditions that can address these specific types of offenses and can mitigate the risk not only of him not appearing to court if the court is concerned about that, but future conduct of this type. The allegations are alcohol, not necessarily any controlled substances. So if the court imposed an OSM or an ankle monitor and even no driving without an interlock device immediately, those concerns would be greatly alleviated because all of those conditions can test for alcohol, which is the alleged substance in this case. So that would be our request today. This is a misdemeanor. It's not likely to be charged as anything other than that. And so these are conditions that he's going to have to live with anyway. So the sooner that we can get him into treatment and the sooner that we can get him started, the better. He will be better off and the community will be better off if he's able to keep his job and to stay in his home.
Oh, the concern is the extensive number of DUI arrests, convictions over his lifetime, in addition to violent convictions as well. He scores an 11 on the risk assessment, and his BAC was high, 2.34. So I believe that therefore there's a risk to the community. Monetary bail is appropriate. I'll set it slightly reduced given the totality of the circumstances. I'll set it at $8,000. That's bondable or 10% cash. So, sir, if you post that and you may be able to if you have family support. You are going to be supervised by pretrial services. They're going to test you for alcohol. I will also include that his case be routed to start the PSS process to see if he qualifies for a specialty court. So that's not making you any promises about anything, but it's just seeing that if you do plead guilty or are convicted of this, you might qualify for some help or assistance. And I would consider in the future, if a residential bed is located, releasing him directly to that bed. But I first want to see kind of how the case progresses and what the PSS says. So those will be the orders. Thank you.
Judge, you want to set the PSS right now?
Yes, just route him to start the PSS.
Okay, I can set it right now for Monday at 1:30. And if he's in custody, he'll get transported.
Okay, wonderful. So Ms. Lopez, just make sure that he accepts that transport and shows up at Monday for the PSS. Thank you. All right, next we have a first appearance for Pedro Lopez.
Your Honor, he waived his appearance today. We are prepared to move forward without him.
All right, probable cause is found, public defenders appointed. Let's start the bail hearing with the state.
Your Honor, I showed Mr. Lopez is already, this is an ad booking for an existing case. There was already a bail set at $50,000 on that case. I'm fine with keeping that amount intact. I'm not arguing for any more bail.
All right. So, Ms. Lopez, what I'll indicate is just technically it's an OR release on this matter only, and then he'll remain in custody on his other case.
Understood, Your Honor.
Then we have a first appearance for Eric McDowell.
He also waived his appearance today, Your Honor, and we are prepared to move forward in his absence.
All right. Probable cause is found, public defenders appointed. Let's start the bail hearing with the state.
Your Honor, the state's asking that the court impose $5,000, just $5,000, not 50. I don't know why I said that. On Mr. McDowell's case, the allegations are relatively straightforward as a battery by an inmate, but what's concerning to me is the fact that he's an 11 on the risk assessment, which is certainly higher on that instrument, and he's got an extensive criminal history. I mean, I'll just start with the beginning and sort of move back as fast as I can. He's got a misdemeanor conviction for paraphernalia and carrying a concealed weapon in California out of 2026. He's got a pending case for grand larceny, felony counts of grand larceny in the Reno Justice Court just this year. In 2023, he had a vandalism case out of California. 22, there's more cases for theft, possession of controlled substance for sale, the latter of which resulted in a post-release supervision violation. There's probation violations in 2021, at least 3 of them. In 2020, a felony conviction for assault with a deadly weapon that also carried a probation violation. The trend continues into 2019 and 2018, for which there's various different arrests and convictions, most of which carry probation violations. 2014, there's 3 distinct instances of probation violations. There's a child cruelty case in 2013 that also had a probation violation noted. 2012, convicted of domestic battery out of California, also had a probation violation. There's a PCS conviction from 2011 for which the defendant's deferred sentence was ultimately revoked. Likewise, out of California, that same year had convictions for theft and challenge to fight. So all the way back to 2011, there's been instances of physical violence. Almost every single entry on Mr. McDowell's history is met with some documented instance of non-compliance. And here, in the custody of the Washoe County Jail, the most supervised place on earth, he can't even abstain from criminal conduct under these conditions. So for those reasons, the state thinks some form of monetary bail is appropriate.
For the defense.
Mr. McDowell is remaining in custody on between $60,000 and $70,000 bondable already. Any amount of bail that the court imposes is outside of his ability to post. We are asking that the court consider setting this bail at $1,000 bondable in consideration of the high bails that he already has. Mr. McDowell indicates that whatever happened, the other person, and I'm not saying that we're going to stay on the case, we might end up conflicting this, but the other person was also put in ADSEG for violence and that he was acting in self-defense. Whether that's true, I'm sure will be determined later when we get surveillance, but we are asking in consideration of his defense and of the high bail that he already has, including a fugitive hold, that the court consider $1,000 instead.
He has a lengthy criminal history. This is a violent act. He scores highly on the risk assessment. I think that $5,000 is appropriate given those things. It's bondable or 10% cash. I won't include any conditions. And we have a first appearance from Michael Quinonz.
He is not present, Your Honor. We are waiving his appearance. We're prepared to move forward in his absence.
Okay, that's fine. One thing I was looking at is I don't believe he filled out or signed the public defender application.
I see. Well, I can inform the court, Your Honor, he is in custody on at least 2 other matters. He's got a no bail hold out of another jurisdiction. I don't know where that is or what it's for. And he has a $1,500 cash only out of Sparks. And I believe that we do represent him on that matter.
All right. I also want to put on the record that I see that according to the pretrial assessment report, he has no occupation, no employer. And I do see those some of those holds. So given that, I will appoint the public defender. If it's discovered later he has means, we can reconsider that. Let's start the bail hearing with the state.
Thank you, Your Honor. The state's requesting a relatively modest bail of $2,500 with conditions to include no alcohol, drugs, paraphernalia subject to testing and supervision. The state's concerns here are not one of community safety based on the allegations necessarily, but rather recognition of Mr. Quinonz's rather extensive criminal record. As indicated in the probable cause sheet, he provided a fake name to law enforcement while at Renown. Ultimately, he's recognized by the police, and it's determined that he's got an existing warrant for his arrest from the Sparks Justice Court. That case is a misdemeanor conviction for battery from 2025, for which the defendant was granted probation. He's also got a bench warrant pending for him on a misdemeanor out of White Pine County. It looks like there was a conviction in 2025 as well for obstructing, and an arrest warrant issued that same year in April from the Attorney General's office for battery by a prisoner with the use of a deadly weapon. His conviction history goes back even further to 2024, where he was convicted of battery on a protected person. In that case, he absconded from probation, which resulted in a bench warrant being issued. That probation was ultimately revoked. He had an FTA that same year as well on that same charge. He's got a felony conviction for robbery in 2017 in 2 distinct cases. He's also got a misdemeanor conviction in 2015 for assault, a felony conviction in 2016 for attempted home invasion. There was pretrial violations, numerous. His dishonorable discharge was granted after being afforded an opportunity at parole. In 2014, there's a misdemeanor conviction for domestic battery, and all the way back to 2009, he suffered a felony conviction for grand larceny of a motor vehicle. He was given an opportunity at diversion. He failed that, was sent to prison, was released on parole, had his parole revoked, and expired his sentence in custody. So the defendant's criminal history is one that reflects non-compliance, and that's been borne out from 2009 all the way to 2026.
For the defense.
Your Honor, I would normally ask if this court would be willing to consider the STAR program for Mr. Quinonz. The only thing that I worry about is that hold out of White Pine County. I understand that he does have a criminal history. I would ask that if that hold is lifted, that we do consider him for STAR. It sounds like while he was only arrested for paraphernalia, fentanyl was found on scene. And if he does choose to participate, if he agrees and if this holdout of White Pine can be lifted, then I think he would be a good candidate. So that would be my only other thing to add.
That may be appropriate down the road, but right now he's got too many cases to unsnarl and holds. So for now, I'm going to set his bail at $2,000, bondable or 10% cash. Reno Justice Court monitoring. I think yes, if and when we could figure out all these cases, he might be a good candidate at some point. All right, next we have first appearance for Chance Rston.
Mr. Rston is also waiving his appearance this morning. We are prepared to move forward without him.
All right, a probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Thank you, Your Honor. The state's making a similar recommendation as the state just did Mr. Quinonz's case for similar reasons. The defendant was ultimately caught using fentanyl and being close to some paraphernalia that was consistent with the same. He's an 11 on the risk assessment. He's got no employment. He didn't provide a reference. And with respect to his prior criminal record, it reflects a pattern of both ongoing criminal conduct as well as noncompliance. It looks like there was numerous cases in 2026 and 2025 that were not issued, so I'm not asking the court to consider that. However, in 2024, he was convicted of the felony crime of PCS. He removed himself from the adult drug court and was ultimately granted probation. It notes that he absconded several times throughout the pendency of that case. It looks like as well in 2022, there was convictions for trespassing in the Reno Municipal Court that also notably had FTAs associated with them. There's a 2018 case that was in the Reno Municipal Court that also produced an FTA. There's a 2017 case for drug paraphernalia that also produced an FTA at arraignment. There's a 2015 case for driving with a revoked license, a failure to comply case in 2013 out of Arizona, likewise connected to a drug charge. So Mr. Rston's pattern of noncompliance has been demonstrable since 2012, and frankly, the state sees no opportunity for that trend to change if he's given an OR in this case.
For the defense.
We are asking for an OR, Your Honor. Mr. Rston does not have gainful employment. He does have an address. He's been there for a month or two off of J Street, but he doesn't receive any government benefits. So he is deeply indigent and really on the verge of homelessness if he doesn't get out of custody. We would ask that the court consider releasing him with supervision if the court were to put him on alcohol and drug testing and regular check-ins, as well as order him into self-help meetings. We believe that the risk that he would fail to appear would be greatly alleviated. Mr. Rston does have a history, but these are the types of offenses that there are less restrictive means than holding them in custody that we can impose. So that would be our request today.
I hear he was previously in a drug court program and removed himself. I also see that he was last released from the jail on June 18th of this year. So I'm just not confident he's going to show up or comply with any of the things we try and put in place to assist him with. So bail will be $2,000 that's bondable or 10% cash. And if he posts, he'll be subjected to Reno Justice Court monitoring. Next, we have a first appearance for Sabrina Taylor.
Your Honor, Ms. Taylor was not feeling well, but we are prepared to move forward in her absence. We're asking to waive her appearance. All
right. Probable cause is found. Public defenders appointed. Let's start with the state.
Your Honor, the state's making a request for $2,000 in Ms. Taylor's case with conditions of no alcohol, drugs, or paraphernalia subject to testing and pretrial services monitoring. She scores in the 8, which places her on the moderate side of the risk assessment. She's got a pending case in the Reno Municipal Court. In that matter, she was cited for possessing drug paraphernalia on April 1st of 2026, so about 3 months ago. She was given it was a citation, so she was never taken into custody, but she was provided with an arraignment date of April 28th. She promptly failed to appear for that. In 2023, she likewise had a misdemeanor citation from the Reno Municipal Court for the same offense, possession of drug paraphernalia. That case as well resulted in an FTA issuance. There's a 2017 conviction for obstructing or resisting law enforcement. She's got a felony conviction in 2013 for burglary and grand larceny, as well as a misdemeanor conviction in 2012 for domestic battery and contempt. Looks like out of the Sparks, and then the contempt came from a tribal court. So given the fact that she's been a recent FTA, there's been repeated crimes in the past as similar to the instant allegations, the state's got concerns about her showing up to any future court appearances and thinks some form of monetary bail is necessary to help ensure her compliance.
For the defense.
Your Honor, when folks are given a citation, they're usually not placed on any kind of supervision. We're proposing that the court release Ms. Taylor with some kind of supervision, both to remind her of court dates, but also to keep an eye on her. We were able to reach out to her aunt, Lona. Her aunt confirmed a couple of things. Ms. Taylor has been working at home care, and she's been doing that for about 1.5 years. In addition, she recently got a second job with her aunt doing carpet cleaning, and she's been doing that for about 2 months. She's been enrolled at UMA Medical Academy for online classes. She's trying to get a new job in the medical field, maybe as a nurse assistant or something along those lines. She's been doing that online, and her aunt also confirmed that that's what the second job is there to pay for. Miss Taylor is reliable. She's been living in her residence for about 5 years, and she has a stable phone number. So with all that being confirmed, Your Honor, I believe that rather than an 8 and scoring in the moderate category, she's actually something akin to a 4 in the low risk category. Miss Taylor indicates that if she is not released, she is going to lose her tuition, and it's going to put her back in her studies. She's working really hard to dig herself out of this hole. Her history seems to belie an addiction, and this instance also seems to speak to her addiction. We believe that if she were to be released and placed on not just supervision with reminders that she has court and needs to come back to handle her business, but some kind of supervision to help enforce the sobriety, that would really speak greatly towards the risk that she presents for failing to appear and committing new crimes in the community. If the court wants, we can put her on, self-help meetings and get started with getting an evaluation. I was not able to speak with her personally, so I didn't ask if she would be willing to participate in the STAR program. But based on the arrest and the substance that is alleged, I think that she would be a good candidate. I would ask that the court consider releasing her on her own recognizance, and when she checks in, see if she's willing to undergo the PSS and get started with some kind of evaluation and see what she qualifies for. Because it does seem like she's probably been addicted for a long time and would be a good candidate otherwise.
Well, her criminal history is not as severe as others. She scores a moderate. I have some trepidation about releasing her, but I will attempt it. So she'll be released. She's going to be subjected to Reno Justice Court monitoring, and she needs to show up by Monday at 5 p.m. And when she appears to check in with us, we're going to refer her to the STAR program. So I'm not going to start the PSS or anything just yet because I want to see that she shows up. So she needs to show up at Reno Justice Court by 5 p.m. Monday. I'm setting her arraignment for August 13th at 9 a.m. And if she's serious about getting some help, she'll show up. Otherwise, obviously, there'll just be a warrant for her next time.
Thank you, Your Honor.
Next, we have a first appearance for Winterhawk Thompson.
Hello, Your Honor.
Good morning. Probable cause has been found, and sir, you've indicated you're going to represent yourself. That might be possible down the line, but just for today, let me ask you some questions. Do you have any job or any income that you make?
No,
That's fine, sir. That's okay.
No.
I'm just going to appoint the public defender's office to represent you. They'll be with you from here on out since you don't have any job or any income. And let's go forward with the bail hearing, starting with the state.
Thank you, Your Honor.
Before we proceed, I want to correct something, Your Honor. Mr. Thompson is not saying that he's unemployed. He's saying that he misspoke when he said he wanted to represent himself. He does wish to have the public defender appointed.
Okay. So, I'm sorry, let me be more clear, sir. Do you have a job or any income that you make right now?
Oh,
and I take care of my daughter while she works.
okay.
Up in school. And
So do you think can you?
Yeah, it's Sanchez in the house. It's on percent.
no, ma'am. No, Your Honor. I don't have substantial income right now.
Okay, so the public defender is appointed. Let's start the bail hearing with the state.
Thanks, Your Honor. The state's asking the court set bail at $5,000 with conditions of no weapons, pretrial services supervision, no alcohol, drugs, or paraphernalia subject to random testing. This is a circumstance in which there is, according to the probable cause sheet, a rather heated argument that elevated to a physical degree. When police got to the residence, they heard sounds of someone manipulating a gun as well as yelling from inside the home. When the defendant was contacted, he submitted to a preliminary breath test that was a .237, and also was seen sort of furtively trying to hide something under a staircase. It turned out to be a Glock 23 that the defendant admitted was his. He's been convicted previously of misdemeanor domestic battery, so he's a prohibited person from possessing that firearm. That conviction came to us in 2021. He's also been convicted of in 2020 of obstructing and resisting, and there's another entry in 2011 for an arrest for domestic battery with no disposition. So given the confluence of those factors, extreme intoxication, verbal argument, a chaotic scene, and a person who shouldn't have a gun in possession of a gun, the state has concerns about the threat the defendant might pose, not only to the community, but to those in his immediate vicinity. He also scores as an 8 on the risk assessment and declined to give a reference at the time. So taking all of those factors into account, I think $5,000 is a reasonable bail to be set to help ensure Mr. Thompson's compliance with any conditions that the court might impose.
So, Mr. Thompson, your history isn't severe, but I do have some concerns. So I'm going to release you, but your case is not over with. If you
Okay.
don't follow these rules, you can be taken. You need to listen right now, because if you don't follow these rules, you can be sent right back to jail. Do you understand that?
Yes, Your Honor.
Here are the rules. You're going to be supervised by pretrial services. You have to start checking in with them right away. They're going to test you for alcohol. You cannot drink.
Nope.
You need to show up for those tests and show that you're not drinking. You also cannot have weapons of any kind. No weapons. None.
Yes, Your Honor.
And I'm going to set your next court date. Your case is not over with. You have to show up in court August 13th at 9 a.m. Start your check-ins immediately and your testing for alcohol. If you do not do those things, I will likely issue a warrant for your arrest and you can be sent right back to the jail. So make sure you understand those things and follow through with them. All right?
Yes, what I've seen through.
Yes, Your Honor. Thank you. Thank you very much.
Thank you. Next, we have a first appearance for Darius Gaines.
Your Honor, Mr. Gaines is not present today. He recognizes that this is a fugitive hold, and he understands that he will be seen at either a 72 or an arraignment on that fugitive matter. He's waiving his appearance. He has been, it's been explained to him the process and kind of where he's at.
All right, that's fine. I'll just place on the record that I found probable cause for the fugitive hold and we'll address it if and when the criminal complaint's filed.
Thank you, Your Honor.
Next, we have a first appearance for Miguel Sanchez.
Okay, good.
Good morning. In this
Morning.
case, probable cause has been found. Mr. Sanchez indicated that he was going to hire his own attorney. Sir, were you able to reach out to anyone to represent you?
I actually was gonna see if I can appoint a public defender.
Okay, so let me ask you a couple questions to see if you qualify. How much money do you make per week?
About 1,500.
And how many people are in your household?
3 or 4 in total.
Okay, so you're close enough to the cutoff, sir. I assume you have other bills and liabilities that you have. So I will appoint the public defender to represent you. They'll be with you from here on out. You can hire someone at any time if you would like to. But let's go forward with the state for the bail hearing.
Sorry, I forgot to take the mute off. Your Honor, in this case, I'm recommending an own recognizance release. Mr. Sanchez is alleged to have shattered a window during an argument with Ms. Monique Medeiros. Our office was able to get in touch with Ms. Medeiros. She reported that she does not want the court to issue a no contact order. She stated she's not afraid of the defendant and has no concerns for her safety. His only other criminal history is an ONR charge with no disposition from 2025. And so in light of those factors, Your Honor, the state thinks an OR is fine.
Right. So, Mr. Sanchez,
Yes, ma'am.
I'm going to release you, but I'm very concerned about this allegation in your behavior. Something like this cannot happen again.
Yes, Your Honor.
So your case is not over with. I'm going to give you your next court date. It's going to be August 13th at 9 a.m. And let me look at one other thing. I'm going to place you on Reno Justice Court monitoring. What that means is you have to come down to Reno Justice Court by 5 p.m. tomorrow. That's Monday. To make sure we have all your information and good ways to contact you so we can send you court notifications. I'm also going to include you cannot have any weapons. I'm not going to do the no contact order, but if you have any other arrests or aggression towards people in this community, you can be sent back to jail on this potentially. Do you know that?
Yes, Your Honor.
So make sure you follow all the laws and show up for your next court date and for your justice court monitoring. And if you do those things, then you can stay out of custody while this case is going forward, as long as you follow those rules. All right?
Yes, ma'am.
Okay, thank you. All right, counsel, I believe that was all for today. Any questions or clarifications? Did I miss anybody?
No, thanks for your time, everybody. Appreciate it.
All right. Thank you, everyone. Have a good day.
Have a good